Good evening. This is a meeting of the Athens Board of Zoning Appeals. The time is 7 p.m. and the date is February 12. At this time, I'll call the meeting to order. The board consists of 5 members and 2 alternates. The alternates take full part in the discussions and become voting members in the absence of a member or when a member abstains for conflict of interest. Present tonight are Mr. Lavelle, Ms. Carson, Ms. Kranowski, Mr. Raby, and Ms. Towsley. We also have present with us John Paskey, who's our zoning administrator, and Secretary Paul Eschenbacher. The board operates under the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions that pertain to the case. The applicant or representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard, and anyone wishing to speak in opposition will be heard. If necessary, the appellant or representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to City Code, Section 230703B, the board has the power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to City Code Section 230910C, variances from the code shall not be granted unless the board finds, based on direct specific findings of fact, that each of the following conditions has been supported. Number 1 is practical difficulty or undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of the regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Number 2 is exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes in this or uses in the same zone. Number 3 is preservation of equal property rights. Literal interpretation of the regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone or the same vicinity. Minimum variance is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. And the last condition is not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by a decision of the board may petition the Athens County Board of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There is only one case on our agenda tonight. The case is 1301V. The property is 363 Richland Avenue. It's in an R3 zone. The applicant is requesting a variance from ACC 230801A to allow a multi-unit apartment complex to have 195 parking spaces out of a total of 856 spaces, each with 170 square feet in area and 8.5 feet in width, where 180 square feet in area and 9 feet in width are the minimum requirements. The board is required to take testimony under oath, so anyone who wishes to speak tonight should stand. Do you swear or affirm that any testimony you will present to the board will be the truth, and nothing but the truth? Yes. Thank you. As I've said, this first case is at 363 Richland Avenue, concerns parking at this multi-unit apartment complex. Mr. Eschenbacher, do you want to tell us things about it?
I'll defer to the zoning administrator.
Mr. Pascal.
As many of you remember, last month the applicants came in requesting a variance for the reduction in the number of parking spaces for the Summit at Coates Run property. They had 36 parking spaces that slipped over the hillside this past spring, and therefore they do not have enough at the 1-to-1 ratio of 856 beds. At that time they were denied their variance request, but they are coming back this time requesting that they reduce the size of 195 of the parking spaces by 6 inches apiece in width, and the removal of some islands that there were landscaping or trees that were in the parking lot, to accommodate. Now they will have the 856 parking spaces again at 195 of them at a reduced size. So that is their request. I have been in touch with the Shade Tree Commission. They are going to talk about it Thursday evening. Our new ordinance, our current ordinance, does not require the islands in the parking lot anymore. So they'll probably have to relocate the trees around the perimeter of the parking lot, maybe on the backside where the slip occurred, but it should not be an issue with what the tree situation is going to be.
Okay.
So
All right.
that's all I have.
Okay. In that case, will the representative or person in charge, if you'll just tell us your name and give us your address and tell us what you think we need to know.
Good evening. My name is Rick Kirk. I'm with the Summit at Coates Run property. My address is 150 East Broad Street, Columbus, Ohio. And I'm here with Ryan Pearson, our land planner, and then Jim Sillery is our counsel here, who will give you some technical details here when I'm finished. Mr. Paskey summarized this as well as I can. I think last month we were here requesting a reduction in the number of spaces, and our alternative still is to add spaces on our existing property. The challenge is that we would have to add them in areas that I think would be detrimental to not only our property, but certainly most significantly the Greenbrier neighbors. So in talking with your staff, we came up with a proposal to, as you summarized, slightly modify the parking spaces by 6 inches. This is a common practice in many areas. All of the cars today fit in these, you could label them as compact spaces, but it's no longer compact. It's just this typical car. This is a site plan that we have submitted, and the area that it would just be one area that we have, which we call our overflow parking and visitor parking, and these shaded areas are the areas that would be either reconfigured or restriped. Technically what we would do is go out and restripe the paving. We do have some islands. All of these islands that have trees we will leave as is. Some of them also have street lights in. We will leave those as is. There is one tree down here. It's about a 10-foot tall tree that we planted during construction that we would relocate to this perimeter island here. But that's the essence of our rework. The reworking would allow us to keep our 856 spaces that is required by code. It would allow us to work within the existing improvements that we've made. We wouldn't have to tear down any more trees or do any more regrading, and so we think with the help of your code advisor here who suggested this initially, we think this is a very good solution. So I'll let Jim respond with some of the technical points here, and then if we have any other questions,
Just
Ryan.
before you
Yes,
leave,
ma'am.
let's check to see if anybody has questions of you before we
Certainly.
get more technical.
Absolutely.
Okay. Questions, anybody, at this point?
Just one quick question. Were any of the already established handicap spaces in the lot affected by the reconfiguration?
No, we still keep all of those.
Okay.
Yeah, that's an ADA federal requirement, and we keep those, yes. I'll leave this up here.
Okay, thank you.
Good evening. I'm Jim Sillery, 35 North College Street in Athens. I want to speak to some of the standards that the board will be discussing. First, will the granting of the variance be in accord with the general purpose and intent of the code for the zone in which the property is located? There are already two large projects on Richland Avenue, Summit at Coates Run and University Courtyard. They've been approved, constructed, and been in operation for years. The variance sought is indeed minimal. That is, reducing the width of some parking spaces that will easily accommodate compact and subcompact cars. The variance will allow the use of the same surface already in existence and will result in no new construction on the hillside. In fact, will have all required parking. Will the variance be injurious to the area or detrimental to the public area? In fact, just the opposite. The variance will not allow any more vehicles than already approved. The variance eliminates the need for new construction on the hill that would require the removal of some trees and further intrusion into green spaces. It would eliminate the concern of those property owners on Greenbrier that the construction of a new hard surface lot would have detrimental effect on their property. What particular circumstances or conditions related to the land or buildings requires the variance? Mr. Kirk spoke to that. I'd elaborate a little bit further on that. The original owners had soil samples, engineering, and architectural plans that they followed in the original construction. Notwithstanding these preparations and safeguards, slips occurred which the owners attempted to correct. Eventually, however, some parking area was lost. This is all related to the nature and conditions of the land upon which this project was approved. The owners were not negligent. They were not haphazard in their construction process or actions, and they've done everything possible to stay within and comply with the code. Why do these circumstances not apply in general to other properties in the zone? Again, this situation is very unique in that the owners had tests and plans drawn and had taken every precaution to avoid any land movement and to correct the land movement after it occurred. Will denial of the variance deprive the appellant of reasonable use of the land and/or buildings? The present parking lots can easily accommodate all the required parking. I think, in fact, they typically have 30 or 40 spaces now that are not being used. When the original code provided for the size of parking spaces, vehicles were much larger. As I recall, when I was back on the zoning board back in the 1970s, the requirement was still the same. 20 feet or 180 square feet, 9 by 20. We all know what's happened to the size of cars in that length of time. The aisleways are still the same width, just the width of 195 parking spaces is 6 inches less. It can easily, again, accommodate the requisite number of vehicles. And frankly, this is the most reasonable use of the land. I think the board knows that the appellant has a bus system that it operates. It really is fantastic, and that it's very, very heavily used by the residents. They obviously would much rather park their cars, keep their cars there. Bus system eliminates their residents driving into town and parking on city streets. That's something they've had in effect throughout and will continue to use. It attracts students who don't have cars, frankly, who want new facilities with the amenities that the Summit of Coats Runs has. And so it does, in fact, attract students that don't have cars. And I think that's the reason why they have so many empty parking spaces now. A denial of the variance request would require the appellant to construct another lot, dig further into the hillside, with the loss of trees and green space. I want to talk about the hardship that would be created by the strict application of the code. It would be a hardship, frankly, because the present lot can easily accommodate all required parking. The hardship would be a loss of trees and green space, and certainly the residents on Greenbrier feel that newly constructed lot would have an adverse effect on their property values. The variance would in fact be a minimum that would allow reasonable use of the land. As I said before, this is truly a minimal variance. And frankly, I believe it would be unreasonable under these circumstances, given the reduction in the size of cars, the fact that we already have a lot of empty spaces, to require the building of another hard surface lot. Obviously, there will be no change in air supply or light supply to adjacent properties. It will not increase any congestion on city streets. We're going to keep the same number of spaces that were always permitted, and it doesn't confer any special privilege upon this appellant. This appellant still has to have the requisite number of parking spaces required by the code, the same as everybody else. So I think that the variance request meets all of the criteria that this board has to consider beyond a reasonable doubt. I'd urge this board to grant the variance.
Thank you. Can you hang on just a minute? We'll see if anybody has a question for you. All right, you must have done a good job. Thank you. Anyone else wishing to speak in favor of this variance? Okay. Tell us who you are and give us your address, if you will.
Stephanie Goldsberry, 20 North May, Athens, Ohio. I was here before, and I had stated my concern about parking, which I've always stated before this group many times in the past. And I spoke up, and I'm very delighted to see the changes they're coming up with, because the big concern was the digging of the hillside. We have property near this complex. I don't know that we would have been directly affected, but I know some of our neighbors on Greenbrier would have. And then just the worry of more slips. And I also stated that I agree that they probably didn't need as many parking places, but I know other developments that have large parking places do not want to see them getting to lower their numbers, because then they feel they're unfairly taken care of. And we already discussed trying to change the rules, and that was said, well, it won't happen. I still think in the long run that's something that should be addressed, especially given the whole situation of the parking. Perhaps it can be a situation that they legislate so many as being for compacts, which would help reduce the area for parking in this town. So, it's something in the future that I think still should be addressed. But I personally and my husband and I are very much in favor of the resolution they've come up with now, and I hope that you will grant them this variance. Thank you very much. Any questions?
Questions, anybody? Okay, thank you. Anyone else wishing to speak in favor? Again, will you tell us your name and your address?
I am Joyce Lambert, and I live at 7 Greenbrier Drive. I think as a resident of Greenbrier Drive for over 40 years, I have a great concern about the neighborhood and preserving the dignity and value of our property. I think this is a wonderful idea. I can't imagine what could happen to that hillside if they start leveling and removing trees. We know that hills do slip in Athens. Fortunately, where we are located, we have been stable, but no one has ever tried to take off the top of the hill and remove trees. So I think they have come up with a viable plan. It is one that I feel the neighbors of Greenbrier Drive could live with. It's something I think Coates Run, the students, the management, they've been great neighbors. We've not been adversely affected in any way. However, putting a parking lot at the top of the hill would adversely affect the neighborhood. So I would thank you for your serious consideration. I really don't see another good idea.
Thank you very much. Okay. Anyone else wishing to speak in favor?
My name is Mindy Heflin. I live at 7257 Beechwood Drive in Athens. My husband and I own the property at 22 Greenbrier Drive. When we purchased this property, we were very excited to offer a nice rental in a quiet wooded setting close to campus. We now own the rental virtually in the overflow parking lot of the apartment complex. The only thing between this house and the apartment building is the hill that's being discussed right now for additional parking. And we would really hate to see both the trees and the hill disappear. I have never, when we've been up at our property, I've never seen the overflow parking lot full or close to full. At 5:30 this evening, my daughter and I drove through the parking lot and counted 140 empty spaces right in that overflow parking area there. I cannot fathom that short of Halloween weekend that would ever fill up. Anecdotally, I work with college students, and I do hear them say quite frequently, I think I'm going to live at Summit because I don't have a car and I can ride their bus. If this decision were sitting on my desk, I would say, they don't even need that many parking spots, but I also understand how it is going to look to maybe other businesses or developments who are being held with no variance to the number of parking spots. But I think if ever a variance deserved to be passed, I think this is a good one, both for Greenbrier and for the community of Athens. So thank you very much.
Thank you. Is there anyone who wishes to speak in general comment, or anybody else who wishes to speak in favor before we move to general comments? General comments, then. Anyone who wishes to speak in opposition? Okay. Let's see where we go from there, then.
I believe you have a couple letters there, too.
Yes, we do, but one of them is from Ms. Goldsberry,
Okay.
and the other one is from Ms. Lambert.
Okay.
So, in effect, they have already covered the letters, but thank you. Let's see where we need to go from here. Anybody got any questions? Do you want Mr. Kirk to come back, Mr. Sillery to offer you more information before we close the floor? Okay. In that case, we will close the floor and we will consider the findings. So, is there someone who wishes to make a motion here? Okay.
I move that we consider a variance from Athens City Code 230801A to allow a multi-unit apartment complex to have 195 parking spaces out of a total of 856 spaces, each with 170 square feet in area and 8.5 feet in width, where 180 square feet in area and 9 feet in width are the minimum requirements.
For the address.
Oh, sorry. And this is case 1301V, and the address is 363 Richland Avenue.
Okay. Second for that?
I second.
Thank you very much. Okay. I think before we actually go through the findings, I want to point to one other thing that came with our information tonight, and it's reference to a case that was discussed last meeting, I believe, at 46 North Lancaster Street. And in this case, the variance was a request to have a larger number of units, from 3 to 5 units. And one of the things that was discussed was the number of parking spaces. And apparently you all did vote I believe 4-1, to allow parking spaces that were only 16 parking, let's see, wait a minute, let me get this right. You decided that you would allow 9 parking spaces to have 162 square feet in each area, where 180 is required. So
No.
these, no?
No.
That was the original request
That's
that
not
I
all right.
believe Mr. Valentour
All right,
reconfigured.
I'll
and
just put that aside then, cross
We'll
that
go
right
over
out.
that in a little bit here. I got,
Okay, sorry about that, I was not here, but that was approved, was it not?
we'll get into that
Okay,
here
all
in a little bit.
right, okay, sorry, cut that out. Okay, are you ready to go through the findings without any further discussion? Okay, our first consideration is practical difficulty and undue hardship. Because of extraordinary circumstances or conditions, a literal enforcement will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. So what's extraordinary here, and what would the hardship be if we said no?
Well, there is enough space for all those cars.
Okay.
It's just the space that all those cars are in. So I think the real undue hardship of use is that the spaces are required to be too large. And I think that because of the extraordinary circumstances that
What is the extraordinary circumstance?
that many of the cars are smaller, can't
We're
use
talking
that.
about the property, not the cars.
Well, the
Okay.
slip.
There you go. Okay. It's a slip-prone area and it has in fact slipped, right?
Correct.
And, okay, and the hardship would be that they would have to dig into the hill, I think, unnecessarily.
and tear down
Right, and you're
trees.
right about the cars and the size.
Right.
I can't agree that the spaces are required to be too big, since that is what's required at the moment. So,
Well, right, but
I
that's,
get your
we're going
point.
to move that forward, okay.
Okay. Now, we've basically already covered the exceptional circumstances, but that is something that we have to consider seriously, and you've already said the circumstances, the nature of the property itself, which has already slipped over the hill and would require construction that might be further damaging if they had to actually build new spaces. The next one is preservation of equal property rights. Literal interpretation would deprive the appellant of rights commonly enjoyed by others in the same zone and vicinity, while a granting will not confer on the applicant any special privilege that's denied to others in the zone or vicinity.
Well, they still have to meet the number of spaces.
Agreed.
No one else has really come forward to ask for smaller spaces, so we can say that we're dealing with that, have they?
What about this?
No, that's
Not
not,
in the same
we didn't
vicinity.
deal with that in that,
Okay.
okay.
All right, okay.
So we haven't really seen that, but
Okay.
I think it's a minimum variance, preservation of equal property rights in that.
I agree.
So we would
Yeah.
not be giving them anything special.
Nothing special. They're
Okay.
still meeting the law and
All right,
number.
the minimum variance. The variance granted is the minimum required to make possible the reasonable use of the property.
I think so.
Why do you think that?
Well, what the alternatives seem too difficult, and this seems to be something that would satisfy all concerned.
Okay. And again, absence of detriment, which is the other side of equal property rights. Will there be substantial detriment to adjacent properties? Then will it impair the purpose of the code?
No, I don't think it
No
would be
detriment.
detrimental to adjacent properties because it's not infringing on them anyway.
Okay, and in fact, 2 of them have spoken, 3 of them have spoken to
Right.
say that they would prefer this to further detriment of the construction. Not of a general nature, the condition or situation of the specific piece of property or the intended use is not of so general or recurrent a nature as to make reasonable the formulation of a general regulation for such a condition.
Only with regard to the size of the parking spaces.
Well, no, we don't really, it's not general yet. It could become general.
Okay.
All right, we hope that enough people won't go slipping over the hill that we'll have to consider
Right.
things. Okay. Any further comments, questions, or discussion you want to have before you vote? We'll start with you, Mr. Lavelle.
I vote yes.
Ms. Carson.
Yes. Yes.
Vote yes.
Well, I will also vote yes, so you have the variance, and you can restripe your
Oops.
parking lots.
Is Thomas the voting member tonight, or Kay?
Thomas.
Okay.
I don't know how you all go about deciding that, but okay.
Very first.
Okay.
All right.
Um,
Thank you very much.
Thank you.
Very first.
We have a little bit of business tonight. First of all,
No, let's.
It's going to be
yes?
more than that.
Yeah,
so
okay. Go right ahead.
Bear with me on this one.
Okay.
Okay. Last month, we heard case 12-20V, I believe it was, which was 46 North Lancaster.
Yes.
Yes.
The request at that time was for a rear yard setback variance, where 40 feet was required, or 30 feet, I don't have it in front of me, and...
It was
they had
40.
40 and 15 feet was allowed, or given, or whatever it may be, that variance was approved, 4 to 1.
Okay, for the setback.
For the setback.
Okay.
The parking part of it, which is not an issue because Mr. Valentor, who's here to speak to it, stated at that meeting that he would revise the parking so that it would not be an issue as far as the space, the size of the spaces. So we took that out altogether.
Okay.
Here's where the dilemma comes in. Reading through the code, and when I originally reviewed the project, I denied the width of the curb cut at the rear of the building. It is currently 80 feet wide, and I made a note that it was to go to the Planning Commission, much like a Title 41 project, for its approval to be 80 feet wide. In further review, I determined that I was incorrect and sent it to the Planning Commission. It should have came here. So I spoke at length today with our law office and parties to be, and this is what we need to do. According to 27 or Athens City Code 23.07.03C, the BZA may reverse orders. In exercising its power, the BZA may, in conformity with the provisions of the zoning code, reverse or affirm wholly or partly, or may modify the order, requirement, decision, or determination appealed from, and may make such order, requirement, decision, or determination as ought to be made, and to that end shall have all the powers of the office from which the appeal is taken. In other words, after speaking to the law director's office, since I determined that this part should come back here, that the curb cut request should come to the Board of Zoning Appeals, it will be a modification of the original variance that was approved last month. What we need to do then is present that part of it into the record, and you are more than welcome to go through the findings on that, but keep it strictly on the findings of the curb cut width. The curb cut width is 80 feet. It's an existing curb cut at the rear of the building, and this is where another dilemma came in. For residential uses in R1, R2, and R3 districts, driveways shall not exceed 20 feet in width at the street. And then it says whichever is greater, and shall not be located between the right-of-way line and the front of the structure, except in front of an attached garage, carport, or parking area. Well, obviously, it says exceed 20 feet in width at the street, and then it says whichever is greater. So something was missing. So I went back and researched and talked to Debbie Walker, clerk of council. In 2004, there was an ordinance passed, and what is missing in this is it says whichever is greater, or I shall not exceed 20 feet in width, or 20% of lot width at the street, whichever is greater. So in this case, 20% of the lot width would be approximately 35 feet is what they're allowed to have by code for the curb cut width to the rear of the building. So their variance request is going to be for 80 feet in width, where 80 feet in width where 35 feet is allowed. If the building was a B1 use, or it is a B1 zone, and they had a B1 curb cut to the rear, the old code in 2001, which I have here in front, actually allowed for that curb cut to the rear of the building to be 80 foot in a B1 section. And that part was stricken in 2004. So the curb cut that is there when the building was built was conforming. But since they are changing the use and it is all residential by code, it must meet the bulk controls of R1, R2, and R3. The use itself is permissible, but the rest of the building needs to come into conformance. The parking area to the rear, or the setback, we already discussed. Now we need to discuss the width of the curb cut of 80 feet versus 35 feet. And I use the curb cut, the term curb cut loosely, because that's just basically a definition for the opening, the width of the opening, not necessarily a curb being there. So,
Are you suggesting that you want a variance for 80 feet because that is what is there?
I'm not suggesting, I'm explaining that that is what is there, yes.
Are you explaining?
I'm explaining that an existing curb cut of 80 feet currently exists, yes.
Okay.
And that is what their request is for 80 feet, where I think the information you have in front of you said where only 20 feet is allowed. That is incorrect as well. After learning this information today, it should be 35 feet as the maximum amount allowed based on the 20% of the lot width. So, learned a lot on this. I spent pretty much all day researching this, speaking with the mayor and with the law director's office.
Okay.
And
I don't see
Debbie
anything
Walker.
in what you all had last time that talks about the curb cut.
We
You have to
didn't
look at his
because
refusal.
at that
Okay.
time I was
Okay.
under understanding it. I was sending it to the planning commission, so I
Okay.
erred in where I was sending it. Now I'm bringing it back here.
Okay.
And then
All right. So essentially, it's a new variance.
no, it's a modification to the one that was approved
Okay.
last time. We did look into that at great length today under Robert's rules, whether or not it had to be a rescind of the previous vote and add further language or treat as a separate case. But the law director determined that it's a modification to the existing variance that was approved, and we would just add this wordage in to the variance that was already approved. But for you to go ahead and proceed with the findings on the curb cut part only, not the rest of the project, because that part was already discussed at the last meeting. So that's what he guided me to tell you. So that's where we're at with this project.
Okay.
Did you go to the planning commission and they said that this is not the place?
No, I followed up with the law office
You just determined
first.
that yourself?
Yes, I did my research and
Are all curb cuts supposed to come before us?
if it is in an R1, R2, or R3 and is greater than what I found now, this 20% or 20 feet, whichever is greater, then yes, curb cut, not all, only if it's in excess of the size that is the maximum.
Okay.
And then it will come here. And this is kind of the fact that some of the wordage is actually missing out of our code, and we went back into our ordinance and found it from 9 years ago. It's kind of brought this to light, so had
Okay.
a lot of fun.
All right, so we're going to address a modification of variance 1220V at 46 North Lancaster Street, which is in the B1 zone. And the issue before us for modification has to do with a curb cut, which is now 80 feet, but which the code currently only allows to be 35 feet.
Correct.
So,
Questions?
questions?
How does this affect the front parking?
The front parking, I assume, will be the same. I mean, the front parking lot is coming out. That's a requirement because front parking's not allowed in the front yard of a residential structure.
Right,
Okay.
but the curb cut or driveway, however we want to look at this, I went and measured, and according to this, the proposed site plan, which was the most recent one we had, on the north side, if that's north, farthest away from the traffic light, it says it's 22, but I measured it at the narrowest point. So that's away from where it bows out. It was 32 feet. So they were totally 10 feet off on what that is. And on the southern one, which is closest to, and this would be on Lancaster, to the traffic light, they claim it's 18 feet 4 inches. It's 25 feet.
Okay, the way this is going to work, this is where they need to clarify from the law director. Two things here. One,
Okay.
we can only discuss the part that's being requested right now, not the front curb cuts. When that comes in, when they submit the drawing to me for the revision, if this gets approved and they submit it to me, I will verify that. It will be the 20% number will be the maximum amount. 20%, keep in mind, that front side, I don't know what the distance is, but it's probably closer to, how many feet, Paul, looking there? I mean, with the radius around that, I'll have to figure out what that is going to be and then allow them the 20% of the width possibly, so close to 200 feet is what the front radius is on that property, that they would be allowed then to have the curb cuts. I will determine that when that is submitted. So, I mean, but
So you don't think we should bring this back and bring all of these at one time instead of piecemealing this?
because that part hasn't been, they have yet to show us to prove that they're going to get the proper parking in here, and I will deal with that when that is submitted to us. Their request tonight, the amendment to the variance is for the rear yard or the rear curb cut.
So we're piecemealing this whole project into play possibly. This would be the second one. We could have a third one, right?
If they submit to me and it does not have the proper curb cut width or whatever, or parking, when they come back with their revised plan, and I deny it, it will come back. But right now, that is not the question that's being asked. It'll be another variance at that
I
time.
realize that, but we can make a decision on that, can we not?
No, you're being asked to decide on the rear one only right now. That's what the law director's office advised me to discuss, the rear curb cut only as a variance to the original one that was approved.
If that's how we were going to discuss it, right? But I mean, originally when you and I spoke, this was being presented to the board whether we wanted to approach it this way or not. And you told me we could decide that.
I told you that I would look into it. And the answer that I got is not to reopen. It's a modification. I was looked into whether or not here's the three options that I inquired about. One, these are under the Roberts rules, that we may reverse the orders. In other words, rescind the previous vote and add further language. Two, treat on a separate case and hear accordingly. Or three, modify the existing or amend the existing variance, which was approved last month, and based on ACC 230703C, that is the decision that we are to go to with this evening, is to modify the existing amendment or existing ordinance that was approved, adding this rear curb cut.
And that was from the law director?
That is from the law director's office.
So in fact, since the curb cut was not mentioned before, this is actually an addition to that variance.
It's a modification. That's the word we need to use, because that's what's in the code, and that's basically what the Roberts rules is saying. The word modification is what applies here.
Yeah, exactly. Well, I'm going to suggest perhaps that Mr. Valentua come and speak to us a little bit.
All new setting here?
Just about the curb cut.
And do I have to say, John Valentour, RBC Architects, 131 West State Street?
Thank you.
I got in trouble last time because I didn't do that. Okay. You know, last month we were here and we presented this project to you all, and it was approved. And the code office did have the curb cut at the rear as indicated something that would be called or dealt with.
Yes, because we do have a letter in our packet from Mrs. Stone about the curb.
So we didn't bring that up. And we don't, the curb cut is existing at the rear of the building, and we were intending to reuse the existing curb cut.
Okay. And I suppose it would seem silly to make it smaller.
Couldn't do that because we need the parking spots.
I see. Okay.
We were going to, and I've got photographs of that street, and I think that the parking lot or the spots will deposit onto the street. Is it Carpenter? I don't know what it's called there. But it's not
really
heavily used.
It is called Carpenter.
I know it is. It's just not really the main.
No, it's not the main road. And I've brought photographs of other properties that abut that street that show everybody backing out onto that street. It's not something that's unusual for that particular neighborhood or that particular area because it's not really a thoroughfare,
right. Okay.
essentially. So that's all we really have to say. about this. I mean, like I said, we went through this last month in terms of the issues that were, I thought, more pertinent in terms of the use modifications that we were asking for. And we're not asking for a modification in the existing curb cut.
Right. Just a modification to variance.
Right.
Okay, got it. Questions, anybody?
You know, and we are addressing, I mean, just, and to go through, we are reducing the sizes of the openings onto Lancaster Street from what they are now. That's part of the plan, is to redo the curbs.
The number of openings.
Excuse me?
You mean the number of openings?
No, the size. They're going to be reduced in width. As was brought up about the existing openings versus the ones that we're planning for the new configuration of the site, they will be modified to accommodate the city's regulations.
Well, it's just difficult, to have to review a case where we were giving the plans and there's, say, the proposed site plans. I mean, you're the architect. We assume that they would be accurate and up to date. And, I found many discrepancies on this when I really thoroughly checked the property. And so I just find
Discrepancies between what's existing and what's proposed.
What's about to exist in the spaces where they're going to be. It's just difficult. So when you don't, the two front curb cuts would be one thing. So they were written in as one thing, and when I went and measured them today, they were totally something else.
Okay,
so.
but again, we're not going to...
Right.
Those are off the table, so
Right.
it's only
Right.
the back side.
They are.
We'll make them comply.
Okay, does that mean they're going to be 35 feet?
I'm sorry?
Are they going to be 35 feet?
In the
We
front?
can discuss them.
That's
Don't
nothing to
talk
do
about
with it.
No.
Betty.
Sorry.
Like Joan.
Sorry, I am easily confused. Okay. Perhaps that's all you want to tell us, okay? Thank you.
Okay.
Anybody else who wishes to speak to this issue?
I can speak if you'd like to ask some questions. Otherwise,
Well,
the owner.
perhaps you could come forward if you have any additional information that will not confuse us further, or me further. Okay. Anybody got a question?
I think I've done a good enough job.
No.
Okay, thank you. I think we've got it. Okay, I've essentially already stated the variance, but somebody might want to reiterate what we are actually going to do as a modification to this previous variance.
Maybe Paul can read the old one and then add this language in.
I was going to say, whoever makes the motion, do you have a copy of the resolution from case 1220? Whoever makes the motion, I would just read that and then add, and to allow a rear curb cut of 80 feet where 35 feet is the maximum allowed.
Okay. We're reading the resolution. Its concerns, as I said earlier,
It didn't say anything.
the property at 46 North Lancaster. We are modifying it. Okay. For variance to allow renovation of an apartment building from 3 units to 5 from ACC 2310 Table A Schedule of Bulk Controls, have a rear setback of 25 feet where 45 is the minimum required, and to add to that the curb cut of 80 feet will be allowed where 35 is the minimum required.
Maximum amount.
Maximum. Second to that?
I second.
Okay. All right. Anything else about this before we go ahead? Yes, he said we should go through the findings. Okay, so practical difficulty and undue hardship. What's the difficulty?
It's already existing.
Okay, and it was previously allowed, not that that
Yes.
really counts. Okay, what would be the hardship?
They would be able to be the parking requirement.
Doesn't fit with the plans.
Okay. Exceptional circumstances that do not apply to other properties in the same zone.
It already exists.
Yeah.
Preservation of equal property rights will not give them more rights than others in the same zone.
Yeah,
I don't think so.
it's an island by itself.
That's a good description, actually. Okay, a minimum variance to make a reasonable use of the property.
Yes.
No,
You say no?
I say no.
Okay. Do you want to explain that any further?
Yes, I think this is how I explained it last time. Reasonable use of the property is to maintain residency and commercial business in a B1 zone. And they could continue doing that. It is a reasonable use of the property. They already have apartments there.
Okay.
And the property could still function, and we wouldn't need to do this, so.
Okay.
that would be my comment.
And anybody want to speak to anything on the other side of that?
I think what we said last time was that the owner said that he was not able to find anyone to run a business on that property, so that it could be argued that he is not able to make a reasonable use of his property that way.
Okay, all right. And it's certainly true that we try to persuade each other from side to side on occasion, but we don't necessarily always agree. We can take that up when we get to the vote. Absence of detriment, is this going to be to impair the purpose of the code or be a detriment to adjacent property, to have a wider curb
No, it
cut?
already exists. It has for years.
Okay. Perhaps not with as much traffic in and out, but still, it's not a busy place. Not of a general nature, is this something that would be so recurrent that it would have to have a special law to control it?
No, I think it is.
Okay. Are you ready to vote? Let's start with Mr. Rebbe.
I'll go yes.
No,
Yes.
Yes.
And I also will vote yes, so the variance is modified.
Modified.
Okay. All righty. The next thing we need to consider is minutes from the last meeting. I was not here. I assume someone has read them carefully.
I read them.
What do you suggest? Should we
Do you
approve
like
them?
them?
I move that we approve the minutes, yes.
Second to that?
I second.
Okay.
All in favor, say aye.
Aye.
Aye. Okay, the other thing that we have to consider, in February, we're supposed to have a business meeting and an organizational meeting.
The official election of Betty to the chair, unless anyone else so desires to run.
Well,
Well, Greg and I backed out.
I had heard, since I wasn't here last time,
Right.
that you had considered it.
Well, so had Greg, and that's what John told me, and so I figured if I backed out, there was Greg, and then Greg said, hat doesn't fit. And it was like, oh, okay. Well, I didn't think of anything quite that clever. I just said, I pulled out, so.
I think John wants more time to work on you guys.
Well, he's
What
not
guys?
here tonight. I think he
You and
was
John?
prepared for us to decide. So, and we need to do that because February is the organizational.
Well, Betty and I
meeting.
spoke. It's a matter of jobs. I have 2 jobs, and I have no time.
Okay.
I have to cancel a job to come here every Tuesday that we have this meeting. So right now, I just don't have that kind of time.
What?
Whereas Betty, my senior colleague, has a little more time.
Well, I am one of the few of you who's not working, and I had said that I would serve this past year, which I did.
You did?
And, I am willing to do it, but if there's someone else who's longing to do it, please speak up.
No longing here.
No longing?
I think it's yours, Betty.
Well, oh, what a great prize. I appreciate it.
Let's make it legal. I move that we elect Betty as chair for 2013.
I second.
All in favor?
Aye.
Aye.
Opposed?
Okay, so,
Aye.
but this is really my last
Are we
term.
railroading you?
Okay.
Well,
Well, I might be able to do it in 2014.
okay, all right. That would be good. Okay, any other business that we need to address?
Yes, we need to thank Betty for being willing to serve as chair.
Yes, yay.
Sweet of you.
Thank you, Betty.
So we're adjourned.